Oh, good morning. Hope everybody's doing well. Excited for everybody to join. Just quick intro. I'm Andrew Luftig, partner here at Chase Perlitz and Luftig. Chris Curtis is joining me. He runs our Trust and Estates department and also our, I guess you can call it our international department. Quick background, I do see some new names. So we are largely a real estate firm, of course, represent buyers and sellers of residential property. Same in the commercial world. We also represent most of the major banks, residential and commercial, landlord tenant, estate planning, and of course, working with international clients. A little bit exciting news. We recently moved offices, so we're now at 1 Liberty Plaza, 46th floor. Hopefully you can see the view. We went from 3rd floor to 46th floor in a building, so we're excited about that. It's a good way to start off a new year. So I see someone's trying to connect to audio, but we'll get started. You know what's interesting? I think the definition, or I know the definition of a foreigner has changed dramatically since I've started practicing, right? I've been practicing for about 17, 18 years. And, you know, a true foreigner in today's world, I think, is somebody that has no connection, you know, whether to New York or the States. Many of our international clients have, you know, whether it's deep ties or, you know, some sort of relationship, you know, for example, with New York. Maybe they do business here. Maybe their children go to NYU. Right? Maybe they have a pied-a-terre here. So when you're speaking with clients and working with international clients, it's definitely relative, right? You have to see and really evaluate what kind of foreigner you're working with. You know, there are plenty of people. Actually, we're working on a very high-end deal right now. The client does no business here, doesn't have a passport, doesn't have a bank account here. So in my eyes, that's a true foreigner. You know, conversely, we have other clients that have accounts set up here, that have children, you know, going to school here, that are, you know, buying the property as a pied-a-terre. And Chris will give a little background on himself and go into more detail. But, you know, the big idea for most of you, and I believe most of you are real estate brokers, is issue spotting, right? I'll give the analogy. Clients come to me, you know, all the time asking accounting questions or accounting related topics. And as an attorney, I'm not giving accounting advice, but I'll carry the conversation for a few minutes, of course, and then refer them to an accountant. I think for you, it's really identifying, you know, when you're working with international clients, what their needs are. And as real estate professionals, we're always proactive. But you have to be extremely proactive when working with international clients. Why? So when you're working with, let's start with an international buyer, you need to think about their sale when they're purchasing, which sounds a little counterintuitive. Why is this? If an international buyer buys in their individual name, generally speaking, of course, and they pass away, they're subject to a hefty estate tax, right? A death tax. Typically if they buy in their individual names. So that being said, we need to set up structures, whether it's an LLC with a BVI as a member, whether it's a trust or an LLC with a trust as a member. When they purchase, number one, to avoid estate tax and to avoid the evil acronym called FERPTA, which we'll get into as well. So even, you know, early as when you start, obviously you build a rapport with the client. Before you know, a nice way, first of all, a great way to add value and show some sophistication is to say, hey, listen, I know we're looking at properties and, you know, with a domestic client, we wouldn't really introduce you to an attorney this early. You haven't honed in on a property yet, but we should get the conversation going with a international real estate attorney or a tax attorney to see how we want to structure this transaction. That conversation could take a few weeks, right? It can take a month until going from conversation to actually having documents and corporate structures set up. So the last thing you want, of course, is for a client to get nervous. Okay, they have an accepted offer. They speak to an attorney and, you know, they're rushing to put together a very important entity, right? It has to be structured the right way. So you want to be proactive, and it takes a little while to really figure out what the client needs. It's not one size fits all, right? It depends on where the money's coming from, what country, assets, what the use of the property is. Do they have children? Are they married? Are they single? So there's a bunch of moving parts. So first, we want to think about the sale. When you work with a domestic client, of course, you might briefly talk about, how long are you owning the property for? What do you estimate? Is this a 3-year or 5-year or 7-year play? But with an international buyer, you must really analyze, how the deal or how the ownership structure is going to take place. And they need time to figure this out. We'll get into a little bit of the nuances, when working with international clients. Big idea is New York, more specifically, is very public, right? We all know that, many like the New York Times and, periodicals like The Real Deal probably have employees sitting at the Department of Buildings trying to see if any celebrity or a known name has purchased property, right? That is very, very rare in other countries. So they're not used to, the public information of purchase and sales, right? And what's interesting is that we've had clients in certain countries where, they don't want people knowing they're buying in their home country because of, kidnapping issues, because of, fraud issues, real issues that affect, human rights. So here we have to explain to them and give them reasonable expectations that while we might be able to protect anonymity, it's never guaranteed. But the reason of their concern, about people knowing how much money they have and criminal activity is not really a concern in the States when you're buying real estate. It's more about, obviously, not everybody knowing what kind of property you bought. But I'll let Chris give a little background on himself and kind of dig into more of the heavy lifting when it comes to taxes and structures. But just as a quick aside, so of course, we've been largely a real estate firm for a while, and the nice part is Chris has come to the firm. Now it's been almost a little over 2 years, so he works a lot. And this is important for you to think about conceptually as real estate professionals. I consider our firm, a quote unquote life event firm. Right? People get married, divorced, unfortunately pass away, and that, relates to real estate transactions. That's why New York City is always, relatively speaking, active, right? There's so many people here, and there's always life events that, push activity, fortunately for us. So handling real estate transactions, so many of our clients have basic estate planning needs, right? Outside of international clients, whether it's a will or a trust, or unfortunately somebody passes away, we can handle the probate and administration in court. So we have the estate set up, and then, it was kind of, to be transparent, a little bit of coincidence that, Chris had this great experience in working with international clients, whether it's New York or Florida, and he can, touch on the countries that we do a lot of work with. But I'll leave with this. We had a very, very large transaction at 56 Leonard. I think it was about a year ago. It was a young Chinese individual who sold his company for $500 million, literally. And the broker had referred a local Chinese-speaking attorney and us. And, it's funny, and I assumed, right, that the attorney, knew how to set up the structure, knew how to protect the client against estate tax. And we, for a little bit, it was touch and go. The client actually ended up working with us. And I said to Chris, why don't we just call this attorney and see what they have to say? And we're friendly. I know who the attorney is, and just see how they were structuring it and what their thought process was. And Chris said confidently, Andrew, we don't need to call them. I know how to set this up. I know everything that we need to know. But it turns out, and it's all friendly competition, but don't assume because an attorney is from the same home country, as the purchaser, or does a lot of residential deals, that they know intimately about FIRPTA, that they know how to set up these structures. To be transparent, before Chris was on board, we would get outside consultants to help us. So it's a very technical, nuanced area, and we're all in a relationship business. We want to protect our integrity and our name. So make sure that whether it's us or another firm, that they can genuinely understand and have done this type of work, because there are a lot of pitfalls and which can lead to actually a lot of expenses and penalties. Chris, the floor is yours.
Thank you, Andrew. It's a pleasure to be here this morning with all of you guys. Thanks for joining us. As Andrew said, my name is Chris Curtis. I work in the Trust and Estates here at Chase Pro. It's Luftig. Before I focus, well, I have experience in both domestic planning. Obviously, we have plenty of domestic clients with your standard estate planning documents, but I've also, me and my colleague Talita, who unfortunately can't be here, she's out on maternity leave, but we work together. We've worked together now for about 10 years and joined the firm together just over 2 years ago. Before coming to the firm, we were at a boutique practice, and a boutique practice that specializes a lot in with international clients. Just a little bit of background about myself. You might hear an accent from me. I'm actually, I was born in Brazil, raised in England and Brazil, and still have a lot of ties to both countries. My colleague Talita is Brazilian. She's a Brazilian and New York licensed attorney. So we especially have a lot of Brazilian clients coming to us. And that is essentially where we started, because when we started 10 years ago, working this area, we would be helping our clients to structure their investments here in the United States. And obviously, one thing that we saw a lot of was that clients, Brazilian clients, the South American clients, or any international clients, they love to buy real estate here. It's a stable market. U.S. is a highly stable market compared to most other countries. It's a safe place to put their money, and it gives them a place to live here. Gives them a place to stay, gives them a place for their families to hang out and to enjoy themselves. So when we started structuring these investments, we started to notice clients that would come to us after closing, like post-closing, and they might have purchased the property like several years prior to the fact, before they came to us. And so we would be doing some estate planning for them, and just doing an analysis. And some of these clients would, purchased in their own individual name, like an apartment in New York for $2.5 million. And we kind of had to break the news to them. I was like, well, are you looking to, and they're in their, 60s, 70s. And I was like, well, you're looking to hold this apartment long-term. And they said, yeah, of course. I want, my kids to live. We love this apartment. I want to leave it to my kids. And then I had to break the news to them that if you pass away, you're going to have a really big U.S. estate tax bill of up to 40% of the fair market value of the property on the date of your death. So, $2 to $3 million apartment, you're looking at an estate tax bill of like $1 million. And the IRS wants their money. The IRS does not wait. It's 9 months after death that money has to be paid. So sometimes they would even have to consider, if they were to pass away, consider a fire sale of the apartment. So we'd have these difficult discussions, and then the client kind of, just looks at me stunned. And this wasn't just one or two, even this was several conversations. They just look at me stunned, and they say, well, why? I had a broker helping me. I had an attorney helping me, a real estate attorney helping me at the time. They all helped me. Why didn't anyone mention this to me? Good question. Why didn't anyone mention it to them? Why? Because people aren't that familiar with it. Real estate's great real estate attorneys. Andrew's a great real estate attorney. He's got a great team, but we're all in our own lanes, essentially. We specialize, so they don't usually pick up on these kind of things. And not all attorneys are going to understand this. So it's something that, at least for the realtors out there, is something, as Andrew mentioned, it's issue spotting, right? It's issue spotting to understand where could there be potential issues for your clients, to just show them that, look, you're not just here to get them over the finishing line and then grab your commission and then just head out. You want to show them that you actually care about them, that you actually have a really good understanding. And no one expects you to become any sort of tax experts or anything like that overnight. It's just to issue spot and then be able to tell them, hey, you may want to have a conversation about this, right? So let me get into a little bit of a nitty gritty here, because I just mentioned this example of the 40% estate tax. And probably some of you may be scratching your heads here. You're like, well, what, why is this the case? I mean, is this going to happen to me? I mean, I'm a US citizen. I live here. Even if you're not a citizen, you live here. Is this am I going to have to pay this? Am my family going to have to pay this? So, and the answer is generally no. If you're a US citizen and, or a non-citizen, but considered domiciled here, it's a very subjective criteria, by the way, then each person has an exemption, a current estate tax exemption of almost $13 million adjusted for inflation for 2023. That was the latest number that came out, $12.92 million, which basically means if you pass away holding assets in your estate less than $12.92 million, you pay zero estate tax. You only start paying from the first dollar after that amount, right? 99.9% of the population does not have $13 million or more of assets. And so they end up paying zero estate tax, and it's not an issue for them. By the way, it's worth mentioning, we're here in New York. I know that we may have people from other states. Certain states do have estate taxes. New York State does have an estate tax. Depends on how that's charged. If you're a non-resident, there's very easy ways to structure things in order to avoid that New York State estate tax. But to suffice to say, if it's their own individual name, New York has a $6 million exemption. Anything above $6 million could potentially be taxed from the first dollar. I won't get into that nitty gritty stuff, but there is a potential for that as well, and potential to look out for. So what's the difference? So none of us, it never applies to us. And that's probably the issue, because it doesn't apply to us. It doesn't apply to 99.9% of Americans or non-citizens domiciled here, like with a green card. And so we don't really consider it. But it really is a huge factor for foreigners, for non-citizens not domiciled here in the United States. Why? Because they don't have the same exemption. Their exemption is a whopping $60,000. Anything above $60,000 is subject to U.S. estate tax, right? And guess what? That also includes U.S. real estate, and it also includes co-op shares, and actually shares in any domestic corporation, right? So that could be a really big bite of the apple. Now, the good news is there are structures out there in which we can utilize in order to mitigate or completely eliminate that risk of estate tax, right? There's some very common structures. I'll get into them in just a second, but basically it's a give and take. I mean, obviously you don't want to, you guys aren't expected to know this. There's some very standard structures, but everything ultimately depends on the objectives of the clients, right? Because you have to take a lot of different factors into consideration. For instance, are they purchasing just for appreciation? Are they going to sell very fast afterwards? What's the value of the sale? What's the value of the purchase, right? Is it long term? Is it going to be for personal use? Are they going to be renting it out? Do they intend to leave it to their kids? Do they actually need the real estate? Could they potentially gift it to someone? And also, are there any do they have any U.S. citizen children or grandchildren that they're potentially looking to leave it to in the future? All of that has an effect in the types of structuring. The good news is there are plenty of structures. We can be very flexible about them. Perhaps the most common one that we tend to utilize, and this tends to be with no U.S. citizens involved, it's long-term, especially rental is very attractive. We purchase in utilizing some form of offshore company. We usually put those in the British Virgin Islands. Now, Some of you might be familiar, the British Virgin Islands in a not so great way, the Panama Papers and everything like that and so forth. It seems to have gotten a very bad reputation over the years. Just to let you know that the British Virgin Islands, there is nothing wrong, inherently wrong, with opening up a company there. It's a very standard company, and it's used very, very commonly with the purchase of U.S. real estate. So we would open up a British Virgin Islands company with the client as could be the sole director, sole shareholder, and then purchase it in either directly in the name of a British Virgin Islands company or a wholly owned New York corporate subsidiary, right? And what's the effect of that? Well, there's not going to be a U.S. estate tax because for U.S. Tax purposes, the client passed away holding the shares of a foreign corporation, which isn't subject to U.S. estate tax, but it is and so it avoids the estate tax. Now, there's all sorts of different. It's a balancing act. This is all a balancing act. If you're looking to, and that's what we have to deal with clients. If you're looking to reduce the risk of U.S. estate tax, then you potentially have to. You're potentially going to have to increase the level of income tax that's potentially going to be paid down the line. Corporate structures are not the most income tax efficient. They help with U.S. estate tax. They help with potentially U.S. gift tax issues, avoiding those. But you're going to have certain higher taxes. Corporate taxes tend to be higher. Here in New York City, for instance, if you put it into a corporate structure, I have to advise the client that, hey, there's a corporate franchise tax that needs to be paid every year. You don't pay that if you put it in your own individual name, right? So there's a lot of different things that we have to analyze with the client, and we sit down carefully and we analyze it with them. Now, obviously, when you have a foreign client, and if you work and here in New York City, you're inevitably going to come up to one. Usually they like to work very fast, right? They love to work very fast, and they're very excited about purchasing the real estate. Don't be put off by considering structuring or having them speak to someone about structure. I wouldn't be overly concerned with, hey, oh my God, now I never spoke to them and now they're going to contract signing or they're about to go to contract signing. This, number one, it should be done ahead of time, especially when you're dealing with real estate. The reason why is that, for a reason it being, is that Andrew mentioned FIRPTA, right? The FIRPTA, which most of you are probably more familiar with, that 15% FIRPTA withholding. That's an extremely complex area of law. But what it basically means is after the foreign buyer purchases it and their name is on that deed, right? It is very, very, the choices are very limited in terms of restructuring that in order to guard against potential U.S. and gift tax issues, right? Sometimes you'd have to essentially ask the IRS permission to do it, right? And they get frustrated. Sometimes you have to do a phantom sale to a foreign corporation, and then they have to pay income tax on a phantom sale on appreciation. So it's key that anything that the client understands this, and we discuss structuring right at the beginning, right? And typically me and Andrew, we work together. Andrew's on the real estate side of things, on the trust estate side of things. And sometimes the deal's not going to stop. I mean, the seller is not going to stop. They might just go to the next person in line, especially here in New York City. So they want to keep things moving. So me and Andrew, typically we have someone who's like, okay, well, we need to sit down and look at this and look at some options, but we make sure that there's sufficient language in the contract that allows for assignment to a potential structure, right? And in that way, that kind of safeguards things. It gives us a little bit of breathing room, and then we put something together that works for the client. So, what kind of things are we typically seeing, especially recently? One thing that we noticed last year, Andrew had mentioned this, is that a lot of parents that are purchasing for their children, right? They have their kids that come here, they go to NYU, they go to Columbia, and they're going to be here for several years. They might even end up deciding to live here, right? And in those kind of situations, parents are looking to purchase an apartment, and so for their children to live in. Maybe they'll rent it out afterwards or so forth. But for now, could even be the kids are going to be living there full time. It's going to be their domicile. So what do we tend to do in those kind of situations? Doesn't make sense for the parents to buy it. Parents could be of an elderly and of advanced age. And a lot of the times the parents have no issue with gifting that money to their kids. They usually trust them. They gift the money to their kids. The kids purchase it. We tend to put it, for instance, in a revocable trust. It's a very straightforward method to do it. So if something happens to the kids, it would go back to the parents. And in that respect, now the kid, the child of theirs still has an estate tax issue unless they become a citizen or green card holder. But then we say, well, look, he's 22 years old, right? He's in good health. Get a life insurance policy, right? Based on the potential estate tax issue. Get a term policy for like 10, 20 years or so. And it's payable to the trust in the event of death. And that usually resolves it. So you don't necessarily have to get into these complex corporate structures or irrevocable trusts. So for instance, sometimes there's very simple ways of doing it, especially for the lower value real estate here in New York City. Now, one thing that I do want to touch upon, and Andrew had mentioned, is FIRPTA, right? You might all be familiar in terms of FIRPTA. What is FIRPTA? FIRPTA is, if you're not familiar with it, it's basically, it's a federal law. It mandates that if there is a foreign transferor, if there is a foreign transfer of real estate, and that could be a foreign individual, foreign trust, a foreign LLC, a foreign corporation. If it's transferring the real estate, then 15% has to be withheld on the sale. So if the sale price is $1 million, there's $150,000 FIRPTA withholding right off the top, and it's sent to the IRS at closing. That is mandated by the IRS for the buyer to do it, right? That's the buyer's obligation. If the buyer doesn't do it, then the buyer is subject to penalties and even possibly subject to paying any tax owed by the foreign seller if the foreign seller skips out and doesn't
just to clarify, it's a withholding, right? A lot of your sellers will get very, very nervous when they hear this and they see it. It's a withholding. Think of it as a security blanket, for the IRS, right? If let's pretend a dramatic situation, you have a seller that has no ties to the United States. They live in New York. They have one apartment and maybe one bank account with minimal money. They sell their apartment and they're, out of the country. How does the IRS protect themselves against collecting capital gains tax, right? So they make the seller hold back money, right, through the transaction, 15% as a security to getting any gains if there are gains. And even if there's a loss, that money still has to be withheld because the IRS has to determine and agree that there's a loss. So it's frustrating, right? Had to deal with this. Number one, we can avoid FIRPTA in many situations, not all situations, by setting up proper structures initially. That's why we talk about, the purchase is so critical. But let's say, for example, you didn't work with them, we didn't work with them on the purchase, and now they're selling. And, sometimes it's difficult. Sometimes they need those funds, right, to pay closing fees. And they may be in a difficult situation. But again, it's a withholding. It's not necessarily, they're not necessarily going to pay 15%. It's very rare they pay that much. Obviously, it would have to be a huge gain. But again, it's extremely technical. It's extremely frustrating and aggravating to deal with the IRS. For example, not to get into the minutia, but some of these forms have to be mailed, snail mail. We can't even FedEx them or do track the how we're sending it, and then of course it gets lost, and then there's penalties and interest, and it becomes a huge headache unless it kind of related to the landlord-tenant world with all the notice provisions. If you want to evict a tenant, very, very technical, and it almost feels like the IRS is trying to collect penalties and interest. But again, the issue when you speak to your clients, it's a withholding, it's not a tax.
Yeah, and it's essentially a withholding mechanism. And I just saw a question.
Just as an aside, I'm sorry, quickly. Sorry, Chris. We are going to send everybody that's on today a pretty detailed presentation, 2 presentations. So that goes through a lot of these different structures and setups. So you'll have your little manual that I think will be overly detailed, but it'll be good, reference point for you. So don't worry about, taking notes or anything of that nature.
And I saw I just saw a quick question pop up saying, how does FERPTA affect green card holders? Green card holders, by the way, are treated like U.S. citizens for income tax purposes. It doesn't matter where they're living right now unless they've given up their green card. They're not considered foreign persons for FERPTA purposes, right? So that's why it's also a careful analysis. You have people on non-immigrant visas. We have to do a careful analysis how many days they are in the country. They could not be a U.S. person. It really depends on the specific factors. But in terms of structuring, and when Andrew said you've also got to consider the sale as well. For instance, with our foreign clients, I had mentioned we would, for instance, create a British Virgin Islands company, but we may not put it directly in the name of the British Virgin Islands company. One of the reasons an income tax issue is a thing called a branch profit tax. It's a real pain, but I'm not going to get into that. But one thing that we tend to do is we create a New York corporation, for instance, that's wholly owned by the British Virgin Islands company. So the British Virgin Islands comes what we call act as a foreign blocker, right, from the U.S. estate tax. And the New York corporation directly owns the real estate. There's some tax benefits there, income tax. It avoids a double taxation if you liquidate the New York corporation. Again, I won't get into the nitty gritty, but one of the important things is that the New York corporation is considered a U.S. person for FERPTA, even though all of its owners are foreign, right? It doesn't matter. It's its own separate entity. And so there's no FERPTA withholding required in New York corporation. Same is true, actually, if, let's say, for instance, the clients decide, for whatever reason, we don't use a British Virgin Islands company, we just use an LLC. An LLC with more than one member, for instance, 2 foreign spouses, that is treated as a domestic partnership. So domestic partnership also is not subject to FERPTA, even though all the members are foreign, right? Domestic trust, you can have a domestic trust. A trust treated as what we call a domestic trust. It has to be irrevocable, of course. If they fund it and so forth, again, not considered a foreigner for FERPTA purposes. So there are different types of strategies in order to avoid that FERPTA withholding, and that's key because that's kind of the elephant in the room, right? You might, some of you that might have gotten a foreign seller, and that's great, and they're like, oh, I really need to sell it. Maybe they need to sell it for various reasons. They desperately need the cash, or they're going to use it immediately after to invest or purchase. Someone has to have a conversation with them and sit down and say, oh, by the way, 15% is going to be skimmed off the top and sent right to the IRS. And if you're lucky, you might get that money refunded to you, any difference within a couple of years. Sometimes it takes the IRS that long. And it's not a pleasant conversation. And then they get very frustrated about it, right? And then they say, oh, well, it's even with a loss. Yes, even with a loss. Now, one of the good things worth mentioning, by the way, is there is a way in which, let's say, for instance, they didn't make the structure. It's too late. Now they're going to sell. And let's say, for instance, they are making a loss, right? It's very clear they're making a loss. Well, technically, FERPTA applies, but there is a procedure. It's called 8288B, Certificate of Withholding Application, where you could actually essentially request to the IRS saying, well, here's the actual tax that's owed. Here's our calculations. Here's a package of documents. Please lower the withholding to 0. And that used to be a really great way to do it pre-pandemic. The IRS is pretty good at responding very quickly in 90 days, so much so that we would, most attorneys were comfortable doing what we call a FERPTA escrow post-closing, because until you get a response from the IRS, you are allowed to keep those funds in escrow. You'd have to send it within 20 days, only 20 days from a response from the IRS from that 8288B application. And then the IRS would usually respond within 2 months after the closing, say, okay, it's 0, and the funds can be released to the foreign seller. Everyone was happy about that. Unfortunately, with the pandemic has created huge backlogs. They were their office in Ogden, in Utah, that handles these was pretty much closed down for a year. And they weren't processing anything. When they reopened, they had a backlog of almost a year that people were waiting. It went from 90 days, a maximum of 90 days, to a year. It's getting better. I think it's about 6 to 9 months now, but they're just hopelessly behind. What's the issue with that? It's a timing issue. It used to be a no-brainer to do it. Now it depends on when closing is going to be and so forth. It's the end of the year. It might just make sense for the client just to file a tax return and do the withholding and so forth. A lot of attorneys aren't comfortable now with FERP escrow agreements, because that means that post-closing they could potentially have to keep their eye on this for perhaps a year plus. And so, we don't like it for our clients if there's a foreign seller, so we tend to avoid those.
There is just, you might get a lot of, hopefully you're not involved in it, but behind the scenes, there's often a push and pull between attorneys, about responsibility for these documents, because there's a lot of liability and headaches, potential headaches involved. Chris, there's a question from one of our.
Here we go. So the question is, first of all, I'm sorry, Laura had a question first. Just let me see if I can answer that. Is this 40% estate tax the case with a domestic death or just foreign? Laura, actually, the answer to that, it's for everyone. 40% in theory starts from, well, it's 40% after $1 million. It's kind of graduated up to $1 million, but it rapidly kind of increases. So up to $1 million, it's about 32% effective tax rate. But then further down the Internal Revenue Code says, oh, well, if you're a citizen or a non-citizen domiciled here, this doesn't apply to you up to $12 million. And Congress is constantly fiddling around with that. There's all these, political discussions with, death taxes and so forth. It was recently doubled in 2017 with the Trump tax cuts, colloquially known as the Trump tax cuts, but it is set that $12.92 million is set to expire and be cut by half, probably around $6 million in January of 2026. So it used to be $1 million. I think about 15 years ago or so, it was $1 million, ridiculously low. And so it really depends on the political climate. That tax is always going to be there. The question is what the exemption levels are, right? And for foreigners, it's been a consistent $60,000 for foreigners for decades and decades and decades. I don't think it's ever been any different. Why? Because foreigners, they don't vote, right? They don't vote. So no one really cares about that. And the buyer, and can the structure be changed after the purchase? Yeah, Laura, I did mention that it can be changed. There are ways to change it and restructuring it, but it can get very complicated because the FERPTA rules, because the FERPTA rules basically say, foreign transfer, it doesn't actually have to be an actual sale. It's just any sort of foreign transfer, especially to like a foreign corporation. Guadalupe writes here, the question is, who from the office should call if you have a client that is not a resident, needs to minimize me to refer them to a lawyer? Call me or Andrew. You can call me or Andrew. Our contact information is going to be on the presentation. That's going to be it's going to be circulated. We'd be happy to talk to you. If a foreign, another question from Alexandra, if a foreign buyer purchases in their name and decides after the purchase to put an LLC, how does this work? Yeah, that could be done. If they want to put it into an LLC, for instance, then what they would do is they would have to obviously, for instance, I do this on a fairly regular basis. I form an LLC for the clients. So let's say it's foreign husband and wife, right? I put it into an LLC. So we form an LLC, which is 50-50 ownership. Then we do a deed where they transfer it to the LLC as a capital contribution. Now, luckily for FERPTA purposes, individuals transferring to a domestic LLC is not subject to any sort of recognition of gain. You do have to do some very technical and specific notifications to the IRS about it, but there's no gain, and there's also no New York State, at least here in New York, no New York State, New York City transfer tax, nor is there in Florida either. Because they own it, essentially. It's just mere change of identity. Now, it's worth noting, by the way, that the LLC in of itself does not prevent estate tax, the death tax on a transfer at death, right? But what it can do, and can be very valuable, and I've done this several times, is that the parents might have a US citizen children, right? And they say, well, it's a rental property. We want to gift it to our kids. We don't want this anymore. So what they, and they don't really want to sell it. So what they do is in one situation, it's rental and it's in their own individual names. We transfer it to an LLC. And then after we transfer it to the LLC, we then gift the membership interest to the children. Now, if they were to gift if they were to deed directly from their own individual names to their kids, there's going to be a gift tax above anything 60,000, which is the same rate of estate tax, right? Gift tax is something charged during life, by the way. That's the difference with estate tax. Estate tax is charged at death, transfer at death, right? So, but if they transfer a membership interest in an LLC, that's considered an intangible. It's not subject to gift tax if it's being transferred by a non-resident alien. It's a little odd quirk in the Internal Revenue Code, but that will be if they die and it's transferred at death. It is subject to estate tax. So there's all these curious anomalies in the Internal Revenue Code that we can potentially take advantage of. And then the children can essentially receive the membership interest gift tax free. They inherit the basis of their parents, but they now own this real estate, and all they have to do is just report the gift the following year. They'll have to pay gift tax on it. Guadalupe, sorry, one more question. By the way, we are in Florida and you're only presenting case about New York. So yeah, sorry, Guadalupe. Yeah, we are. I do Florida. Florida, by the way, Guadalupe is much more straightforward than New York. Much more straightforward. For instance, like New York, Florida doesn't have an income tax for individuals. It doesn't have an it doesn't have a corporate. It has a corporate tax, but exempt from anything under $50,000. Rental income is typically zero taxable because it gets so many deductions. Florida is a lot more straightforward, Guadalupe. This kind of planning, by the way, it involves federal tax law, so it really kind of is uniform across the country. Having said that, Florida, for instance, doesn't have the same franchise taxes we have here in New York. I love Florida. I absolutely love Florida because it's just so much more straightforward to plan there. Mike Riveron asks, explain how you can avoid FERPTA when the property was purchased under a buyer's name initially. It's not possible you can create a BVI after purchase. Mike, you can create a BVI after purchase, but the issue is when you create a BVI, it's a foreign corporation. First of all, foreign corporation will be still subject to FERPTA. The foreign corporation can help with US estate tax. But if the individual was to transfer it to the BVI company, FERPTA forces a recognition of gain. And also requires a 15% FERPTA withholding, as they treat it as a phantom sale. So that's an issue there, number one. Number two, still subject to FERPTA. Now, Mike, something we could do is, depending on the situation, of course, is what I just mentioned. You don't have recognition of gain if, for instance, you transfer the real estate to an LLC, and if it's just one member, for instance, then we transfer one person that owns it. We could potentially transfer it to an LLC. We could then add like a spouse, someone that their child, whatever, with a tiny minority, 0.01%. That creates a domestic partnership. Now you have two people, even if they're foreigner. The tiny transfer won't be subject to gift tax because it's got almost no value to it. It's like I mentioned, it's actually an intangible, not subject to gift tax anyway. So then you have a domestic partnership. Domestic partnership's not subject to FERPTA. So that's one potential way. Having said that, it's a big caveat here. We really can't do this, like literally a couple of months before a sale. We really can't do that. It's bad faith. The IRS can take a look at that as just a mere way in which to try to avoid the FERPTA withholding. It's pretty transparent at that point. So this is something that typically has to be planned either at the beginning, right at the onset, or when the client's considering, I have a client right now, Brownstone, in which both clients are known individual names. They don't want to sell. It's being rented out for a long time now, but they're considering selling in the future. Perfect opportunity. We throw it into an LLC. Two spouses own it. They could potentially gift membership interest to their U.S. citizen child. And then when they sell it, there's not going to be any FERPTA withholding. So there is ways to do it.
Just quickly, Chris, I have to jump in 5 minutes, but Chris will be on to, if you want, anybody has additional questions. Just some, I guess, some practical information when dealing with international clients. Number one, you know, it's a little bit more, I would suggest, Chris and I would suggest a little bit more hand-holding once they close, right? They may not be familiar with real estate taxes, with insurance, you know, with monthly fees, common charges, and maintenance. We've seen situations where they simply don't pay the fees, right? And then we get a letter from the condo or you know, or the Department of Finance where they haven't paid their monthly carrying charges. So a little bit more handholding, you know, even calling Time Warner, you know, cable providers, right? Setting that up. They're just not, you know, used to have, you know, New York, of course, or other states probably. Another piece that just slipped my mind, you know, of course, at least in New York, you know, condos are easier, you know, for an international purchaser to buy in. Obviously, homes, you know, townhouses are no issue at all. If I represent a seller that's selling to an international purchaser, right, even though the condo can't, quote unquote, reject a buyer, they still, especially for an international client, especially with no ties to New York, they're going to be, you know, a little bit more detailed and thorough with the application. So we add language to the contract that says, in the event the condo asks for a guarantor, a year's worth of common charges in escrow. Sometimes, you know, it's very hard, an occupancy, you know, agreement, the purchaser will agree to it. Because if you don't have that language, that would be deemed a conditional consent. Condos are not allowed to give conditional consents, right? They have a right of first refusal. They either waive the right or exercise the right. Technically speaking, you know, the condo can't do it. It becomes a little bit of an issue for some buyers, and they push back, and the condo, you know, becomes a standstill until one party gives in. If I represent a buyer, conversely, even if the seller doesn't ask for that, I want to give my buyer reasonable expectations that the condo will ask for this most likely. Not maybe one of the 3 items, but just be prepared, right? Because people get offended, of course, very easily. And it's not, you know, they're not, you know, singling them out. The building, any building wants to make sure a buyer doesn't become a financial liability to them. So make sure, you know, if you're a seller, you're protecting the deal. Sorry about the lights. If you're a buyer, and even if the seller doesn't request this language, tell your buyer this may come up, and just be prepared. You know, title insurance, mortgage tax, closing fees. We have a service here for any of your clients. We'll send closing cost estimates. With international buyers, you know, so critical, I would say, to send that out early, you know, while they're initially looking at the properties, because again, the hard costs in New York compared to other places within the country, and certainly outside the country, are substantial. They're different. Definitely when you're working with condos and even new developments. New developments are great, you know, because nobody looks at the structure, nobody cares. The title company, you know, will care, but I'm talking about there's no condo board, right? And certainly no co-op board, you know, unpeeling the documents. Any other practical information?
Yeah, a couple of points. Like you already mentioned, Andrew, that you know, the privacy issue. That's really critical. Bring that up. We usually bring it up with the client, a foreign client, because, you know, it's a database, it's a public database, and we're used to it, but foreigners are not. In a lot of countries, real estate records are almost treated like, you know, like we treat tax records. And so I have had in the past foreign clients shocked to find out that if you just Google their name, it'll come up with the ownership record. They come to me and say, I need this removed. Well, we can't. Once it's recorded, it's there forever. It's part of the chain of title. It's there forever and ever and ever. So that's worth getting out there, you know, even if they don't care about structuring to avoid estate tax, they might care about privacy, put into an LLC of some sort. Title insurance, it's key to have a conversation. We can obviously have that conversation with the client. But title insurance is very uniquely American. It doesn't really exist even in other common law countries in the world. Clients get very confused by it. They kind of decide that they want to treat it like a homeowner's insurance, and they say, oh, I don't need that. I don't want title insurance. And technically, they don't have to get it, but that's that's like legal suicide when you purchase real estate here in the US. So these are the kind of conversations to have with them, you know, and no one expects you to be a property manager, but, you know, very simple things go a long way. These clients tend to be, you know, served hand and foot in their home countries. And then they come to New York and they're just like, you know, anyone else. And so things like, you know, oh, you know, it was a pleasure assisting you. By the way, just make sure, you know, here's where you sign up to, here's a link to sign up for, you know, Con Edison. Here's where you pay your property taxes. You know, here's some links here. You know, just keep an eye out for that. Like Andrew said, I had a client one time, and he was even a real property investor in his home country, so was very familiar with how things work with real estate. And he purchased a property here in New York City, commercial property, didn't end up paying the real estate taxes for like 3 years. And we only came across it because he wanted to buy another property and wanted to get a mortgage backing the initial property of collateral. Came up in the title search, in the lien search and tax lien search. And
just quickly, I apologize. Just want to thank everybody for joining. Definitely stay on if you have questions. And we'll send you some information, some detailed presentations, which you can dig into this weekend if you'd like. And of course, call us if you have follow-up questions. But thanks again.
Yeah. All right, thanks, Andrew. So I think that's about it at this point. I think we're just about ready to wrap up. Just want to see if anyone has any more questions. But if you don't have any more questions, you know, please, or you come up, think of a question afterwards. Please feel free to email me or Andrew. You know, we like to make ourselves available to real estate professionals. And we'll see what we can do to help, you know, but the key is, you know, issue spotting, see if a client needs to speak with someone, do it sooner than later. 15% FERPTA withholding may apply. If you're a realtor and you're scared of having that conversation with your clients, feel free to send them to us. We'll explain it to them, and we'll gladly take that bullet for you on your behalf. Or see if we can avoid it. So, but other than that, you know, it was a pleasure having you all, and hopefully look forward to working with some of you in the future. Thank you so much, and take care.